I'm Beverly, and I'm on the witness stand. Well, hello, and welcome back to the witness stand. I'm Beverly Meekum, your nosy court reporter. So I want to start today. It's Monday, June 29th. This may not drop until tomorrow. We'll see. But I wanted to let you know that there was a pretrial hearing today. It was called a status conference. Let me make sure of that. Yes, status conference, but it's really just a pretrial hearing. Let me set the stage a little bit. This is the Alec Murdaugh case, and if you will follow my videos, I have several parts getting ready to drop, which gives you kind of background of the family who's who and what's coming up in the trial. That's going to be important since it's been so long since that trial. And the second thing is that if you've never seen it, you won't know what's going on. So make sure you check out those other videos. But for you enthusiasts who wanted to know what was going on today, I'm here for you. Okay, so in this particular trial, the attorneys for Alec is the same as before, Dick Harpootlian, I like to call him Pooter or Pooterhead, and Jim Griffin. And then the prosecutor goes back to Creighton Waters. So the same attorneys. Now, Creighton Waters has a team of attorneys from his office also. So it's, Creighton Waters et al. Okay? The judge this time is Judge Deborah R. McCaslin. Now, I like her. I really do like her. I was wondering why we didn't have the previous judge, which everybody loved. But it turns out he retired. And I don't know if they would have him at all again because his trial was overturned. So I don't know, because he made some rulings that they're using as reasons to go back and retry, which worked. Okay, so today, what they did was, and I love this, the circuit court judge, McCaslin, implicitly signaled that she intended to run a tight courtroom, stating that when she got that case, it became the oldest case on her docket. And she intends that she is going to move this trial along, and she does not grant continuances. Now, I'm sure if there was some major reason, maybe she would, but that's what she said. And then Harpootlian stated that the defense, of course, needed much more time for extensive additional testing on, like DNA and blood, just a lot of different testing, and the enormous amount of information to review. I don't understand that, because they already have the same materials. They should already know it. Maybe review a little bit ahead of time, then a little bit ahead of time, then a little bit ahead of time. But unless they've not added anything really new, and if they have, then that would be the piece that I would think that you should concern yourself with. However, that's what he said. And he said that if they got all of the additional discovery that they were expecting from the prosecutor's office, he was looking at potentially trying this case in 2028. Not gonna happen. Okay, so not the trial, but what was discussed today was the motions, the responses, and the discussions was first over, this is the defense, over prison laptop access. Kid you not. Defense motion was they requested Murdaugh be granted access to a laptop in his prison cell to review the massive discovery and case materials. Harpootlian argued that without it, the defense could not be ready until late 27. Remember, he'd already said 28. Harpootlian said it was just impossible to drive, I guess, from his office to the prison to babysit him while Alex reviewed the material and then drive back 5 days per week. Can you imagine how much money that cost? I bet it's a pretty penny. Now, apparently, at this point in time, they cannot leave any paperwork. Somebody has to be there. They have to trudge in all this paperwork and then Alec review it. And Harpootlian said for 3 hours. And then they have to pack it all back up and take it back to the office and do the same thing the next day. And he said they just could not possibly do that. Again, I don't understand why we are reviewing. Now, on the laptop situation, Judge McCaslin revealed that she had personally called the prison warden, and he refused to allow a laptop due to security, and because no other inmate had one, why should Murdaugh be any different? But he did offer a private conference room for, gosh, I cannot speak today, but offered a private conference room for review. I don't know what they'd been doing before, because, oh, you know what? He wasn't in prison last time. He was in jail. So I guess they had a whole new setup, and that jail would have been near the attorneys. Okay. All right. So I can see. The judge said that he would not limit their visit to 3 hours. He said if they needed it, they could be 6 hours. But, and I think he's like an indefinite period of time during that day. So, you know, as far as the laptop was concerned, the judge denied the motion for now. Sidebar. It was stated that Alec had already gotten in trouble with the iPad. I don't know exactly what he did, but in prisons nowadays, they get access to iPads where they can email family and stuff like that. I don't know how it works. I don't know if it's encrypted. I do know that everybody has access, all law enforcement has access to it. So I don't know exactly what he did, but apparently he violated the rules and that was removed. He had access removed. So now they're talking about giving him a laptop. And I will tell you that this came up multiple times. You know, you talk about something else, then the laptop. We talk about something else, and then the laptop, multiple times. And the judge again said that she denied the motion. Then the courtroom, and that whole thing about getting in trouble for the iPad came from the prosecution. Okay, courtroom shackles and his jumpsuit. The defense motion argued that presenting Murdaugh, Alec, Murdaugh, you'll hear me say everything. But that presenting him in an orange jumpsuit and chains before televised media would taint the potential jury pool. Now, I don't know. I would bet anybody on the East Coast, at least in the southeast coast, does not know about this trial. I think it's national because of some of the national, like Court TV, Law and Crime Network. I think everybody is aware of this trial. And if you did follow the previous one, or if you didn't, Murdaugh pled guilty on a slew of financial crimes, which came out in this particular first trial. He got so many years for those financial crimes, which we'll discuss in one of the later videos. Make sure you go back and you watch those because they will be dropping soon. He got in so much trouble. He got so much time. He's never going to see the light of day. So everybody knows he's in prison. Everybody. I don't know how you could taint the jury pool with that. You could put him in a suit. You could do whatever you want to, but everybody's going to know he came from prison. Right now, he is scheduled to appear in an orange jumpsuit, handcuffs, and leg irons. I don't know if they call them irons anymore, but I like it. Leg cuffs, whatever. He'll be chained up. So there was a heated exchange in the courtroom, and the defense had briefly withdrawn this with the state, but renewed it again at the hearing. State response. Okay. I just lost my place. I have notes. There's so much stuff I have to keep up with. Okay, state response. Waters, prosecutor, countered that Murdaugh isn't special, stating that the shackles are basic prison security policy and noting that his imprisonment is his own fault due to separate financial crime convictions. So there was a discussion back and forth. No official rule change was made. Murdaugh remains shackled in his orange jumpsuit for the hearing, but there may be another ruling on that. I don't really care. Because I honestly think that nobody whatsoever is going to not know that he's in prison, that he's just being, trying to make him look good, dress good. I don't know how you could think that people would think, oh, because he's dressed in a suit and tie or whatever he's dressed in, that he's not a prisoner. Inmate, they call it now. Okay. Then there was DNA testing. The defense motion requested that DNA found under Maggie Murdaugh's fingernails, which SLED previously attributed to an unknown, unrelated male, they wanted to be sent to a private lab for independent analysis. I guess it was only analyzed by SLED, South Carolina Law Enforcement Division, I think it is. But here was the discussion. The defense offered to pay for the private testing, which Judge McCaslin said, well, I'm going to let you pay for it, which kind of drew a little bit of laughter in the courtroom. However, she deferred a final ruling demanding more information on the following: how long the analysis would take and if a viable sample even exists, which that became an issue. Was that an issue that I was watching another court case? No, this was not. Okay, the sample even exists, so they would have to find that out. It was at this point Griffin stated in a discussion. Now, Griffin is the other attorney, Harpootlian and Griffin. Griffin stated in a discussion with the lab that they were looking at, so he's talking to the lab, and the lab's asking him about the trial. And he says that they are looking at spring to early summer of next year in 27. Don't let us hold this trial that long, and I don't think we will because of what came a little bit later. Now, I want you to also draw back to what I said earlier about Harpootlian making a comment about he just didn't see how they could do it until 2028. Then he backed up a little bit and said 27, and now Griffin gets much more explicit. So in order to do the trial in order for the DNA results to be ready for the trial in spring or early summer, they said they'd have to put a rush on it and hope that they were ready. Okay, potential be okay. Again, refer to Judge McCaslin's statements regarding moving the trial along, and that she does not like delays and did not grant continuances. Now, I'm sure, again, if some unforeseen situation came up, she might revise that. But as of now, that is what she said. So then the defense wanted a change of venue. The defense's motion said that moving the retrial outside of Colleton County, where it was tried before, and the 14th Judicial... oh, gosh. Okay. Outside of Colleton County and the 14th Judicial District. I still don't have that right. And the 14th Judicial Circuit. Now I have it, which I think is pretty much the same thing as a district. And he argued that the case was, it was so saturated in that county, in Colleton County, and all of the media, and the fact that everybody knew about it. He said that also Murdaugh's family's ruined reputation would prevent him from getting a fair trial. The discussion came because the state had not yet filed its formal response to moving the venue. So Judge McCaslin deferred the decision to the next, which there will be a next pretrial hearing. So legal experts note that Aiken County and Saluda counties are currently being eyed as potential alternative avenues or venues. So I went back and I looked up. If you drive from Colleton County, it takes roughly 1 hour and 45 minutes from Colleton to reach Aiken County, and about 2 hours and 20 minutes to reach Saluda County. Both options move the high-profile Murdaugh trial significantly northward and away from his family's historic legal stronghold in the Low Country. I don't have a problem with them moving the venue, but the problem here is that I don't think you're going to be able to find anywhere that this case is not known. So I don't know that it's worth it. I mean, I know that the jurors will be picked from the venue site, or the county where the venue is. But still, you've got the lawyers, you've got the prosecutors, which I'm sure they'd stay in hotels. But you got all these people, and witnesses that live in Colleton County would have to drive this distance to testify. So Aiken County, northwest, probably reverse from you, northwest of Colleton County is situated right along the Georgia border. And it's part of the Augusta metropolitan area. So if you know where Augusta is, then that's about where it is. So moving the trial here pulls the jury. I don't know what's happening to me today. I can't speak. So if you move it there, you're going to pull the jury pool entirely out of the 14th Circuit, which was a core demand from Murdaugh's defense team. Now, if you go, I don't know if they've ever done that before. They may have. I think it's usually they try to stay in the same circuit. And circuits can be more than one county. So we might have to look that up. Then think about it. Okay, and then if you look at Saluda County, that's north central South Carolina. It's located further north than Colleton. and it sits just west of Columbia and the Midlands region. This, Saluda, I told you, is 2 hours and 20 minutes from Colleton. This is a highly rural county, and it offers a completely different demographic than what the original trial jury was. In coastal, Colleton County was coastal, sort of. Okay, so Colleton County forms part of the South Carolina Low Country, and I'm sure if you've ever heard of South Carolina, you've heard about the Low Country. And the Murdaugh family served as the chief prosecutors, or what they call them there, solicitors, for about 86 years at the time of the trial. I think Murdaugh was aiming for solicitor at some point, but that'll never happen. But the defense, because of that, rules that a fair local trial is impossible. I would say that given that you have Randy Murdaugh, which is Alex's brother, who's in the same law firm, with his years now, they might be getting close to 100 years of prominence in that county. Now, here's interesting. The next pretrial hearing is set for August 14th, with all motions due by August 7th. So the judge says, I want the motions so I can review them and have them ready for August 14th, where decisions will be made. And she told him, don't send them to me at the last minute, because she ain't going to be happy. Then the trial date was set by the judge, and here is what she did. It's tentatively, but go back to where she said she likes to move these along and she doesn't like delays. Are you ready for this? April 5th, 2027. So there's a hard deadline. Now, there will be probably multiple pre-trials between now and the new trial. I will update you on all of those as they happen. But this is the first one, and I wanted to give you that information. And I will be here for the August 14th. Now, again, I will be dropping. I've got 3 episodes ready, and I'm going to be dropping them soon as I finish editing. And it will give you the backstory of the family. It will give you the trial highlights and stuff. And then it will give you the reason that the trial was overturned, and it was a doozy. So that's coming. Watch for that in the next week, and you can get updated on everything. Thank you for your watching, and thank you so much for bearing with me while we started anew with the whole new look coming. And I appreciate you, every single one of you. Don't forget to give me comments and subscribe, like, and share. And until then, you may step off the witness stand. I'm Beverly, and I'm on the witness stand.